Welcome, 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 guys. Welcome to Justice is a Process, coming to you live right now because we are going to have an important discussion about what's happening in a courtroom right now down in Georgia. The reason why I'm talking to you tonight is because I want to bring a very important aspect of what's happening down there. We're going to discuss what the judge is doing down there in this courtroom. Number one, I mean, there's a lot of what this judge is doing that's concerning, but what happened today rises concern to the judge attempting, I believe, to try to shut down camera coverage in this courtroom. And we're going to lay out the playbook tonight, what I think she's doing, what I think she set up, because this judge has been doing everything she can to try to deprive Edric Faust of a fair trial, from sustaining objections of the state that shouldn't be sustained, overruling objections by the defense that shouldn't be, allowing evidence in that's not scientifically proven, and just doing everything in between, left and right. But this is a judge that appears to be desperate to remove the eyes and ears on this case. So we are going to be watching, and we need to be watching because this is very, very important.
Day, and I'm going to release all of you. So I'm going to give you the same instructions that I have before and a few extra instructions, actually. So first, I do want to tell you exactly what I've told you many times. Somebody's ready to go. I got that. Please don't, of course, discuss the case. Don't do any research. Don't go to any of the places that you may have heard about. Don't talk to the case, of course, with anybody, particularly at home. I know you all have been abiding by all of that. We have talked a little bit about social media when you all first were impaneled as jurors, and I want to talk to you a little bit about it today. I'm going to ask that you refrain as much as possible from using social media of any kind. And the reason for that is this. There has been recordings on social media of certain times that this court has held some hearings outside of your presence. And we, of course, do that outside of your presence for many legal reasons. And many of those moments have been captured on social media. And it would be improper for all of you to view those moments, where I'm sending you to the jury room for a reason, for legal reasons. And so out of an abundance of caution, because that seems to be happening, I would ask that you try to refrain from social media as much as possible. Now, I realize, of course, the Olympics are on, for example, and people are watching Instagram and things of that nature. And I certainly hope you all can enjoy those moments on social media like Instagram. But many social media sites could potentially share, inadvertently, share some scenes for you that are not meant for your viewing as jurors in this case. So I'd like for you all to be aware of that and try to stay off of social media sites for that reason. All right. Other than that, I'm going to tell you again how much I appreciate your patience. I'm going to release all of you. We'll see you tomorrow morning at 9 o'clock in this courtroom. Thank you. Reminding me, it is not acceptable for any party, whether it's media or persons, to actually participate in the live stream from the courtroom. It is not allowed for any media person to be commenting on live stream in the courtroom or for any other persons to do so. The reasons for that are many, but very particularly participating in live stream comments and blogs of that nature during the trial in the courtroom has not only an impact upon the integrity and dignity of the court, which is 22G1D. It has a significant impact on the administration of the court, which is 22G1E. And it is certainly participating in the live stream and comments of the live stream during court proceedings, according again to 22GIF, has an impact upon due process and the truth-finding function of this judicial proceeding. It has come to my attention that there are there is a significant impact from social media with regard to this trial, and it concerns the court about the security of persons involved, the security of the court, the security of the jurors, and the integrity of the process. And so those are the reasons I'm making my order with regard to any comments about live streaming or doing live streaming during court other than the pool that has been allowed by the Rule 22. So I just kind of want to make that clear for everybody. And I thank you for your cooperation. All right, is there anything else?
All right, guys, so there you have it. That is what the judge had to say, and I hope you paid close attention to what she said, because we're going to break down what she's saying and the disturbing nature of it. And the question I'm putting before you after listening to that is the judge building a case to kill the camera? I believe she is, and we're going to get into why I say that. Now, let's get into this here. So, first thing to understand is this. What is Georgia Rule 22? What is she invoking as she stood in the court or sat in the courtroom? Georgia Rule 22, it's Georgia's Uniform Superior Court rule governing the use of electronic devices and the recording of judicial proceedings inside courtrooms. It controls who can bring cameras and recording devices into a courtroom. I want you to make sure you understand this. Inside courtrooms, 24-hour advance notice and formal application to the judge. The judge gets to deny or limit the recording based on specific findings of harm, and it presumes that this will open up courtrooms, and denials require specific findings on the record, which is what I'm saying is happening right here, and which is what I'm saying in real time we're watching. So what happened today? You watched it. Here's what I say happened. Event 1, Rule 22 request was filed. Now, the second part that you saw was prompted because it was part of a Rule 22 hearing, because an independent journalist by the name of Sylvia Tumusimi, infamous Sylvia Media Services. Check out our YouTube channel. It's Infamous Sylvia. Give it a look. She filed a Rule 22 request. She only wanted access to the pool feed and access to be able to text reporters outside the courtroom, because she's inside the courtroom covering it. So she wanted to have access to the pool feed and to be able to text and talk to reporters while she's inside the courtroom. The state objected, raised concerns about disruptions in other proceedings and allegations of giving jurors nicknames during the YSL case, and they opposed any additional recording devices. Of course, they don't want any recording devices because they want this whole thing to be done in darkness so they can railroad this guy straight in, because they believe the ends justifies the means, regardless of whether or not the evidence actually meets the legal standards or not. What the judge did in this instance is she did grant pool access, and then you saw that after she did that, that was what you saw was when she decided to add the bonus time. And then unprompted, she declares that participating in live stream comments or blogs, any media participating in live stream comments or blogs about that trial is prohibited, and she cites Rule 22 G1D, G1E, and G1F, which is ridiculous, because media should be able to comment on the live stream that's going on. She's overreaching here massively. But I believe what she's trying to do here is she's trying to set up an actual reason, because if that was actually a reason to shut it down, she would have shut it down by now. But she can't, because she can't do that. But what she's doing, and what she did when you saw what she did with the jury, she's inviting something to happen so that she has now already made her record on the record. And this is what she put on the record. She cited 3 specific Rule 22 factors. And these are the factors, and this is, a close eye would not understand what she's doing. But these are the 3 factors that she needs to establish on the record to shut this thing down. All she needs now is an event. She cited 22G1D, integrity and dignity, which is impact upon the integrity and dignity of the court. The way she claimed that this was being violated is she claimed live stream commentary, meaning comments in live stream, live streamers commenting, reporters commenting during trial impacts the dignity of the court. What impacts the dignity of the court is her actions and behavior in that court, the prosecutor's actions and behavior in that court, and the attempts to try to circumvent due process and to try to circumvent the rights of the defendant, to try to go ahead and essentially install a guilty verdict, which is what she's been trying to do from day one, is the reason why, as we're getting to in a little bit, why before the trial she almost got kicked off the case. Next thing is 22G1E, which is administration, impact upon the administration of the court. She claimed that social media coverage is creating an administrative burden on the court. Okay. No, what's creating an administrative burden on the court is that she's not getting away with what she wants to get away with silently. And she now realizes that people are watching, and it's got her scared because that creates the environment. She's either got to get rid of the cameras or she's got to adjust her behavior because she realizes the whole world's watching, and not just watching, but that these things are being clipped and they're being delivered and they're being pushed and they're being put out there. And she's being called to task for her biased behavior. And the next is 22G1F, which is really rich, due process. She claimed that the impact upon due process and the truth-finding function, she claimed online commentary threatens the truth-finding process, which is absolutely outrageous because what threatens the truth-finding process is blocking evidence or allowing evidence that science doesn't support and confusing the jury. And that she claims that the state, that the defense can't bring things in because it confuses the jury, but the state can bring things in that absolutely confuses the jury when when you don't even know where this evidence originated at, when the chain of custody has been broken, when you've got slides that have been broken, when you've got, and again, this happened earlier today where earlier in the trial where she would not allow testimony, it's actually yesterday, where she would not allow testimony regarding a hair on a purse due to due process, but then because the defense wanted to bring it in. But then when there were when there were chain of custody issues, but then cited chain of custody issues on the reverse side when the state wanted to block the defense from bringing something in, very similarly said no, the state's jury can't see that because of chain of custody issues. Again, you can go on and on with this case of how unfair this judge is, and I know Mr. Cruz, whoever handles the appeal, if one is necessary, we hope that one does not become necessary if the state's evidence doesn't get stronger than it is, that appellate lawyer will have a field day. And by the way, Mr. Cruz is a very experienced appellate lawyer. That's one of his specialties, which is why you see him perfecting a record against this judge, and she doesn't like it. And that's part of the problem. So now, what happens here today, what you saw, and I'm going to lay it out for you and walk you through the process that she's trying to set up here. There's a standard instruction she's been given the entire case. Do not research this case. Do not discuss it on social media. Do not seek outside information about the parties or evidence. It covers everything. It gives jurors nothing specific to go look for, all right? And that's the whole purpose of it, because you don't want them looking, right? And you don't want people watching. You don't want family members. You don't want anybody exposing the jurors to anything. Instead, what she does is she changes it up today, right? Claiming to change it up because of concerns. And she says to the jury, you heard it, there have been recordings on social medias of hearings held outside your presence. It would be improper for you to view these moments. And she told jurors that there are specific forbidden content out there. And she gave them a reason to go find it. I want you to think about that. She gave them a treasure map, basically said, here it is, go find it. Don't follow it. Don't look at it. Remember, my sister did an experiment with her little son and put these little chocolate chips on in a bowl and set up a little camera and said, okay, don't eat these till I get back. I got to go, over here and get something. And sure enough, he ate it, right? It's the whole idea. When you tell somebody, don't go find it, they're going to go find it. She's setting that up. And the reason why she's setting that up, hold on here. The reason why she's setting it up is because there's a 4-step playbook. I've already explained to you that she's made a record for the 3 key points to kill the camera coverage in there. She built the record. She cited the 22 factors. They're already mentioned: security, jury integrity, threats to the process. That's done. That's on the record. She's already done that. Next, she's planting the seed. Now she's waiting for the violation. Any slip by anyone, a juror sees something, a commenter IDs a juror, an autopsy photo leaks, one mistake by anyone is going to become the justification this judge is looking for to shut down media coverage on this case. And then what she's going to do is pull the cameras and revoke the pull camera under 22G1 and frame it that she's protecting the defendant's fair trial rights, which is laughable for this judge to think that she's protecting, because she ain't got any interest in this guy getting a fair trial. And again, I'm not sitting here telling you, I'm not supporting Edric Faust and saying he's innocent. I don't know. I have not seen this case beyond what's in this courtroom. What I can tell you, though, is this judge has had no interest in a fair trial, and it's disgusting, and it's terrible, and it must be called out. And this judge can't get away with being allowed to kill the camera coverage, because that's the only thing right now that is keeping this thing even at all fair. And right now, look, this judge, online coverage is protected. What she's done is she's trying to reach into a place that she has no business reaching. Rule 22 governs only that courtroom. The rule controls recording devices inside the courtroom. It does not reach commentary on publicly available footage from outside the courthouse, let alone from anyone broadcasting. Many commentators are broadcasting from other states, okay? So she has no right to tell anyone broadcasting from another state that they can't comment on this case. She's got no jurisdiction to out-of-state commentators, okay, that are who are not parties, attorney, witness, or present in the courtroom. Prior restraint is never constitutional. She needs to understand. I'm sure she understands Nebraska Press Association versus Stewart. It's a 1976 case, and its prior restraints on reporting about criminal trials face an almost insurmountable constitutional barrier under the First Amendment. That is the protecting function that says, and my dad tried to do this, even as an attorney. It's one of the cases when we get into further segments on his career, he actually attempted in West Virginia to shut down press coverage of a case. It wasn't video cameras at the time, but it was news coverage. And the footage is already public. So we got Fox 5, Atlanta News First, 11 Alive, Red and Black. They're all using the same pool feed, Law and Crime, and they're using publicly authorized footage for commentary and educational purpose. Is protected speech. This judge is trying to wade into affecting protected speech. And what does this serve? Who does the darkness she's trying to create serve? She's already been accused of bias by the defense before the trial began, because they filed a motion to try to remove her, which she was allowed to stay. First day of the trial, she fines the defense attorney $1,000 and thinks nobody is going to pay attention. She went after him in opening statements and fined him $1,000. That was an immediate threat to this attorney to say, stand down. That was her attempting to try to intimidate him by saying, I'm going to fine you. And the next day, he was even saying, I'm intimidated. He's putting that on the record. I'm handcuffed. She didn't like that. And it was getting people to notice. What she didn't realize is that, listen, there's an avid community out here that's watching these trials, that are interested in things like this, and are not going to just let this go in darkness. She did the wrong thing. She told him that she tried to tell him that he was having a slight tantrum when he moved for a mistrial, which he was absolutely entitled to do. She denied a recusal motion that he filed in the middle of the trial based on it because of her pattern of conduct. And now now she's trying to restrict public commentary on all this. And this should absolutely bother each and every one of you out here who's watching these trials, because this is not how it's supposed to work. You do not have a judge who's done these things, who's trying to now limit. Why? The question is why? Why is this happening? And it's not because Mr. Cruz is some terrible lawyer. Now listen, what are we going to watch for next, right? We're going to watch for escalated jury instructions, okay? This is what we need to watch for if you're watching at home, because this is all going to lead to the bottom there, which is pulling the camera. We're going to watch for escalated jury instructions. Expect tomorrow that she's going to come and she's going to start asking jurors more aggressively, have you been exposed to coverage? That's a setup for a violation. She's hoping that a juror will say, oh, I ran into this last night when I was watching the Olympics, when I was on Instagram, when I was on YouTube. She's going to contempt threats towards the media. Any suggestion that commentators or media outlets are violating Rule 22 by analyzing public footage from outside the courtroom, she's going to be coming at it. She's going to be letting them know, I'm going to hold you in contempt. She's going to be looking for reporters texting in the courtroom. She's going to have her bailiffs on alert. Security concerns on the record. She's building a case that online coverage creates safety issues, and this becomes justification for revoking camera access. Expect Mr. Yamachili, or I think that's how to say the name, and Mr. Bolden, both to be coming in and saying, "Oh my God, I'm getting threats." That's what they did in the Tucker case, and they were trying to go after it. And eventually, when they got the new judge after the mistrial happened, because it was a hung jury, what they did to Ty Tucker down there once they removed the cameras from the courtroom is absolutely unspeakable and horrendous. And then the end game, of course, to this will be pulling the camera, citing the record that she's building to eliminate public access to this trial, where she's been accused of bias publicly by the defense attorney, and where her own actions have invited allegations of bias, because it does appear she's biased. Unfortunately, that's just the way that this appears. Look, what we need to understand, okay? Oh, this comes directly from the Georgia Uniform Superior Court Rule 22, Section A. And she needs to live up to this. Open courtrooms are an indispensable element of an effective and respected judicial system. I repeat, open courtrooms. This is coming directly from the Georgia Uniform Superior Court Rule 22, Section A. The judge needs to remember this, and then she needs to respect this. She says she respects the law. She says she's worried about due process. Then respect open courtrooms and let the cameras show what's happening and start respecting due process rights. Start letting the evidence come in. Show the world that you are running a fair courtroom and you will not have problems. No one is trying to get in the way right now of a fair trial. We want a fair trial. We want a fair showing of the evidence. That is not the point of what's happening out here in the commentary that's being shown and what's being demonstrated for the public. If she puts a fair trial on, we will show a fair trial. There will be, and the system only works when we watch. The process only matters if we question it, and that's why we're here, and she should know that. She should not be afraid. Any judge that's afraid of questions, we should be asking why, and that's what we're doing right now. So if this judge succeeds, if court coverage gets cut, I have shown you how she was doing it. I have told you and shown you what I'm detecting, and if she follows this playbook, if you see it, I've shown you what she's trying to do, okay? I have a good instinct for these things. Watch. That's what we're supposed to do here. It only works if we watch it. Now, I'm going to be doing some more commentary on the case as this thing gets closer, because this is one of those ones that I have to get involved with. I have to speak on it because there's a lot of stuff going on. There's a lot of questions. And there's a lot of people out here that are stressing about the DNA. But listen, you're going to see it. I think, I understand where this defense is going. And I think the defense, regardless of how this judge is trying to portray Mr. Cruz. And has Mr. Cruz made some mistakes? Everybody makes mistakes, okay? But I'm telling you, he's being misportrayed by this judge. They're going out of their way to make him seem incompetent. They're going out of the way to try to make him seem like he's being obstructionist when really it's the prosecutors and the judge that are playing that role. But Mr. Cruz is an experienced appellate attorney. He doesn't have a 30-year background behind him, but he's a fighter, and that's what I like. He is fighting. And he is not just fighting for Mr. Faust. He's fighting for due process. He's fighting for this system. He's doing what you're supposed to do when you have people in this courtroom that are not trying to have a fair and just and inequitable trial. And he's fighting. And that's what we want, okay? It is not about the outcome. It is about a fair process. And that is what Mr. Cruz is trying to do. And he's saying, let's let this be fair. Put all of this before the jury. And if this jury comes back in a fair trial with all of the evidence, so be it. His client gets convicted, so be it. But what he's saying right now and what you're seeing is not a fair trial. It's not a fair shake, and that's not okay. But I think you're going to see what he's going after. And what I will preview, what I believe he's going to say to the jury when it comes to the DNA, is that if you have Mr. Melton, right? If you accept that Mr. Melton's DNA is there, and it seems that everybody has, and you accept that Mr. Faust's DNA is there, right? You can't have two people's DNA in one place. It doesn't make sense. And the reason why Melton's DNA doesn't make sense is because before he ever knew there was DNA, before he was ever trying to explain it away, he said he hadn't been with her for 10 days. That DNA couldn't have been there. In fact, the best he's come up with is 6 days, and it's questionable whether or not that DNA would still actually be there. So what that tells you is there's a problem with the test. And the issue with this is that the test that's being used is a highly sensitive test that has a very high error rate, and it should never be used as the sole evidence to convict anyone. And that's the problem in this case. That is the only evidence. The state has put up the idea that just because, and maybe it was Mr. Faust walking around the neighborhood, it's simply because Mr. Faust was seen walking in the neighborhood that he's guilty of this crime. They've shown no timeline that links into the crime. They've shown no fingerprints, no hair, nothing. We're supposed to say that this man essays this woman and leaves no hair fibers, leaves no evidence, leaves nothing but microscopic DNA that isn't even detected on a test, on a assay kit at the time. And that's what's left behind in this brutal crime. That makes no sense. That makes no sense. And that calls into question whether or not what they say happened actually happened the way it did. And whether or not this was a scenario where we have clearly a relationship that's that's not going well, and something happens. This is an incredibly personal crime that we have no idea why Mr. Faust would do anything like this. And if this is all that's going to come in, if this is the case, this case should absolutely, without a shadow of a doubt, be a not guilty. It's horrible that the family doesn't have closure, that they don't have something better than this. It's a shame that Mr. Melton wasn't pursued, and all of those things should continue to be looked into. But to convict anyone on the evidence that's been presented in this courtroom, and we'll see what comes in tomorrow, and we'll see what comes in those subsequent days, would be an absolute travesty of justice. Okay? And this judge is not interested in getting the fair story out to this jury, and she's doing everything, so are the prosecutors, and that to me is something that just can't stand. And I can't stand to see it. And listen, by all means, if you have the goods, then I am not here to try to help convince somebody that someone's guilty or innocent. I'm here to watch the process, and I'm here to commentate on the process. And when I see an unfair process, that's what my dad used to say. He was not present. A good defense attorney, you understand, you're not there for the outcome. You're there to make sure that regardless of how terrible the crime is, that you see that your client gets every right that they're supposed to have, and that is how it's supposed to work, and that the process works. And that does not mean it always results in not guilty. That doesn't mean it always results in guilty. That means that it's a fair process. Every right is done. Every right is respected. All the evidence is reviewed. All the questions are asked. And at the end of the day, we can live with the outcome then at that point. Okay? That's what we're looking for. And what's happening in this courtroom is not that. And we need to stand up. We cannot accept that this is what's happening right now, 2026. It's not acceptable. We have cameras, we can see it. And if this judge tries to shut those cameras down, we need to stand up and we need to say no. That can't be allowed. So we'll see what happens. In the meantime, guys, until we speak again, let justice prevail, and I'll talk to you soon.
Systems rigged, man, it's time to break free. Eyes wide open, gotta see what I see. Standing on the front lines, fighting for the truth. Lift the veil of lies, it's time to be the proof. Take a stand, don't you back down. Raise your voice, let's shake the town. We're the voices that won't be ignored. Breaking chains, yeah, we're ready for war. With the power of the people